Glossary of legal terms: dismiss, dismissal, motions to dismiss. Brought to you by yourlegalag.com, your advantage if you're being sued by debt collectors. Hi everybody, this video, part of our glossary series where we explain legalese to ordinary people. You'll find the link to a page linking all the glossary videos and the glossary itself in the video description below. We tell you what the term is, what it means, and what the legal context is, and we point you to other sources of information if necessary, and then we discuss what it all might mean to your defense. The terms in this video are related: dismiss, dismissal, motions to dismiss. Dismiss means to drop whatever you're dismissing out of the lawsuit, or to drop the lawsuit itself. In most states, parties can voluntarily dismiss their own claims without even getting permission from the court. In the federal courts, in some states, you have to ask the court to dismiss your claim if you want to do that. If you have one, you can dismiss your own claim or lawsuit. You can also ask that the other side's claim be dismissed. There's more than one kind of dismissal, and we'll start with full versus partial dismissals. A full dismissal of a lawsuit simply ends the case. Once it happens, the court has no further jurisdiction unless it has reserved jurisdiction of some kind in its dismissal. Courts will often reserve jurisdiction, for example, to enforce a settlement. Failing that, though, the court loses all power to do anything else related to the case. There is no case, no discovery, no subpoenas, no motions to quash, no motions to force anybody to do anything. It's over. And so before the case gets dismissed, you want to make sure that all of your business is concluded. On the other hand, there's partial dismissal. When that happens, some part, but not all of the case is dismissed. The court retains full power, including the power to reinstate the previously dismissed part of the case. It retains complete jurisdiction to do anything. So a partial dismissal is not nearly as safe as a full dismissal. Claims can be dismissed with prejudice or without prejudice. And all that means is that you can either refile the suit or not. If the case is dismissed with prejudice, it cannot be refiled. If it's dismissed without prejudice, it could be refiled. Regarding debt suits, a dismissal without prejudice is not likely to be refiled, although it could. But there can be important practical distinctions between the two kinds of dismissal, even in debt cases. Dismissal with prejudice kills the suit and the claim. That could have consequences tax-wise and also as regards your credit report. Dismissal without prejudice leaves some things hanging around. Dismissals can happen because one of the parties asks the court to dismiss a claim brought by another party, and you ask the court to do that with what's called a motion to dismiss. They can be dismissed voluntarily for various practical reasons, or they can be dismissed by the court on its own motion. The court might not be satisfied with the amount of effort that you put in. It could dismiss your case because you don't show up. It could, or for various reasons of its own. Now let's talk briefly about motions to dismiss. We have a lot more material on our site and even a product or two that could help if you needed it, so we'll keep it short here. There are two main types of motion to dismiss. The first kind centers on jurisdiction, the power of the court over the kind of case or the person being sued. The most important example of this is where you are not properly served. The court must obtain jurisdiction through proper service. If it fails to get that and still renders judgment, the judgment is subject to nullification at any time. No time limits, but you have to prove you weren't served by persuasive evidence, usually called clear and convincing. If you file a motion, particularly to get rid of a case where the court doesn't have jurisdiction, then you simply make those arguments. The same as being sued in a place you don't live. The court has to have links to the jurisdiction, to the lawsuit, or to you in order to exert jurisdiction. If it doesn't have that, you can file a motion to dismiss. The other main types of motions to dismiss are based upon the form or contents of the petition. Let's say it isn't clear, or it doesn't state a claim against you, or it breaks some procedural rule. Whatever the situation, you want to decide whether to file a motion to dismiss before you answer. It's possible to waive your argument by answering. And that could mean effectively consenting to the court's power over you when it couldn't happen otherwise. Except for attacks on jurisdiction, remember that motions to dismiss are based on the pleadings and not evidence. A lot of people ask me whether they should file a motion to dismiss because a debt collector can't prove its case. The answer to that is no, because the time for proof comes later. Motions to dismiss are based on the pleadings. Finally, if you do file a motion to dismiss, it isn't necessary or wise, usually, to answer whatever part of the petition you're seeking to have dismissed. If you're only trying to get part of the case dismissed, you have to answer the rest of it. But if you're trying to get the whole thing dismissed, you shouldn't respond. Shouldn't file an answer at all, right? Of course, you know you can't take any of my videos as legal advice. They and the glossary are educational, made by someone who used to practice a lot of this kind of law, designed to help you develop your own judgment. Most people can represent themselves in debt cases because of the kind of law it is and the kind of business it involves, but you don't have to do it alone. If you are, in fact, representing yourself, you may want more help. That's where our memberships and products come in. You'll find the link to the glossary, as I said above, below in the video description. You'll also find a link to our page linking all the videos in this series. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. YourLegalLegUp.com